Q&A starts, like fill out this, and then you can start filling out. Like,
I already have people in the meeting room. Wow. Okay, so I launch it. So I see on the other side.
IP considerations. This I'm saying from the perspective of the eShape IP and Innovation Office. And I'm very pleased to have this nice collaboration with the European IP Helpdesk and Christian in particular, who has already shed light to some points around the technology transfer. Some of you might have been there in the previous webinar. If not, it's also, I think, available online. So here I only want to point out the fact that this forms part of a more concerted effort that we have had in eShape, trying to look into these aspects, trying to understand how people developing Earth observation solutions might, at the end of the projects in which they are involved, face certain barriers for commercialization. So I'm very much looking forward to what Christian will tell us and guide us. I invite all of you to be active in this interactive session, and I look forward to what we will learn all together. Thank you very much.
Thank you, Lex.
Okay, so I guess it's my turn now. Thank you, Francesca and Lev, for this kind introduction, for the opportunity to be here again. As you just mentioned, I had the pleasure to be with you last year on the topic of technology transfer. And today we're going to focus on the topic of commercialization and licensing. This is, as mentioned, a cooperation with the European IP Helpdesk. And as you see in the title, it's basically the basic seminar on commercialization. So if I'm able to hook you up on the topic, you would like to learn more about this, just wanted to mention at this point at the very beginning that there's actually an advanced seminar on this topic on the European IP Helpdesk. Okay, so as I said, big pleasure for me to be here with you and spend the next sort of 1 hour also together with you. Brief introduction, if you hadn't been with me the last time. Christian Hackel, as mentioned, I'm managing director of the company TUM Tech. I've been doing this for quite a while. TUM Tech, just a brief explanation of the name. TUM stands for Technical University of Munich, Tech for Technology Transfer. However, we are not the internal tech transfer office of the university, but a separate company working closely together with the TUM, but also with other universities and research organizations on this topic of tech transfer and commercialization. In addition, I'm assistant professor at the chair for technology and innovation management at the TUM and lecturer for the European Patent Office and the European IP Helpdesk. Wrote a couple of papers. I'll show you one at the end. And to make sure it's not all about theory, I'm co-founder and managing director of a startup in the area of renewable energy, not in the area of space, unfortunately, but in the area of renewable energy. Quick look at the agenda. I'll spend very few minutes introducing the European IP Helpdesk for you, what kind of services, free services they're offering for you. If you'd like to explore this topic of intellectual property a little bit more. And then we go into the topic of commercialization, starting with the topic of open innovation, commercialization, talk a little bit about the why actually does it make sense, what is this, what you should do before negotiation. If you want to move forward to a licensing agreement, we have a quick look at the core content. And as I mentioned at the end, I'll show you one of the case studies and a few comments on the negotiation will be the final wrap up. Okay, as Francesca said, I'll try to make it a little bit interactive, asking you some questions in between. If you have any troubles understanding what I mean, please write your question in the questions box, in the chat box immediately. Otherwise, we'll have the Q&A section at the very end. Okay, to start with the first part, European IP Helpdesk. It's basically a free service initiative of the European Commission for SMEs and also beneficiaries of EU-funded projects, researcher. It's a free support, first-line support, and it basically, on the right-hand side, you see all the different kinds of formats where we try to give this information in forms of training, as we have today. On the website, there's really a lot of information up there, for example, publications, and we have a helpline, a very important part of our work, where you can really address a specific question for you, really asking for confidential advice, obviously first level advice. So you cannot ask, oh, please write me a patent application, for example, but really more strategic advice. Does it make sense in this case to file for a patent or so? This would be typical questions here addressed to the helpline. Then we have an ambassador network and quite many events online and on-site. Here we are in the middle, it's the European IP Helpdesk, and there are a lot of siblings around there. China IP Helpdesk, India, Southeast Asia, Africa, Latin America. So if you are, for example, a researcher based in Europe and you have a specific question, maybe regarding a possible cooperation with a counterpart in India, and you have specific question regarding the Indian IP system, so the India IP SME Helpdesk would be a good advice for you to talk to. As I mentioned here on the website, there is really a lot of information in different formats. It's e-learning modules, it's guide, it's fact sheet, and so on. So it's really worth having a look there. Maybe especially interesting for you, it's a special new guide just recently released on intellectual property management in Horizon Europe projects. And sorry, unfortunately, we had to move our website on the website of the European Commission. So unfortunately, the links here are quite complicated. They used to be rather easy, and now they got a little bit more complicated. As mentioned, we have an ambassador scheme. So if you have a specific question or would like to get in contact with an ambassador in your specific country in Europe, there is in these 27 countries, there are at least one, most of the time, two ambassadors in your country, which you can also turn to for some advice. And here just a list of really further learning opportunities. Sometimes it's a little bit confusing. So many institutions, activities, projects out there where you can turn to regarding advice or learning opportunities for the topic of IP. So here, this is a list of potentially interesting opportunities for you to get some more advice or get some more information. Well, that's about it regarding the introduction of the European IP Helpdesk. And now, as mentioned, I would like to move on to the topic of commercialization, starting with the topic here, closed and open innovation. Again, if you have been with me in the last seminar on tech transfer, some parts might sound a little bit familiar. If not, we do a little recap here. That's basically what we call the innovation funnel. You start out here with many, many ideas, and each bubble is sort of representing an idea. And you move further down the line. So you start with many ideas, you select the most promising one and bring them in the development phase. Again, you select the most promising ones and bring them in the testing phase. For example, you build a prototype and so on and so on. So the funnel is getting more narrow. And finally, you have one or two or very few of these original ideas, which you bring onto the market in forms of new products or services, and hopefully you make good money out of it. That's inside the company, that's outside the company. And here you have very thick, heavy walls, in this case, separating inside and outside the company. That's what we call closed innovation. And as you probably can assume, If there's something like closed innovation, there is the opposite, what we call open innovation. And open innovation means these used to be thick, heavy walls open up. And so it's possible to bring an idea which was generated inside your company to the outside world. And obviously the other way around, you bring an idea which was generated outside the company and you bring it into your company. And basically from them on, you treat it like an idea which was generated in your company. And as you can see here, you can bring in an idea from the outside world, either at a rather early stage or at a rather late stage. Doesn't make any difference. So we have these two directions, inbound and outbound. What we call it inbound would be this one, outbound here. And this basically is open innovation on this side of the equation. And here we talked about exploitation before, bringing ideas, product, services on the market and exploit them on your own. Or you can have the exploitation done by others. And this is also a form of open innovation. And this is in the area of commercialization, and that's what we're going to focus on today. So basically this part shown differently, you have some kind of IP, and IP in our case stands for intellectual property. And as mentioned, it can be used and commercialized by the IP owner, or it can be used, commercialized by somebody else. And very important, we are not talking about infringement. So we are not talking about anybody stealing your ideas, but really somebody else, a third party, is using your ideas, but the third party is entitled to do this. So question to you, can you think of any ways how a third party can commercialize an idea, but the other party is entitled to do it? So we're not talking about infringement. Any forms you can give the right to use your IP to any third party. If you have any idea, you can type it in the chat box as the first participant already did. So we have the first answer already coming in. It's license. Thank you for this one. Next one was franchise, employment. Any other ideas from your side? If you think on IP, you'll be focusing on IP, intellectual property, and sale, yes. So basically, we got the important parts, joint venture just coming in, yes. So yes, maybe, thank you for this one. Let's have a look, basically, what we have. And as you mentioned, yes, you can sell your IP or you can license it. And there's also the form of spin out. Spin out, some people like to see it as a third option. Sometimes spin out is regarded as sort of a sub form of either selling or licensing. Spin out, especially from research organization, mean that you have a team of researchers or students basically forming a company, building on the knowledge they have generated, for example, through their PhD project, and the know-how belongs to their organization, the university or research organization. So basically, they need to be able to work with this know-how, which belongs to the organization. So they need to build upon either a selling the IP, that the organization is selling the IP to the spin-out, or licensing. So basically, we've already mentioned one of the options that if you're in a university, we basically have all three different forms. A university can sell the IP either to a spin-out or to another company. They can give a license, and we have the form of the spin-out. In the company world, we mainly have selling, which is called transfer of ownership, and licensing, and less the form of spin-out. Sometimes you have it in the area of the business world, but most of the time you have transfer of ownership and licensing. And selling is basically a one-time transaction. The buyer and the seller, they agree on the price and that's it. Licensing is, at least in my opinion, much more interesting, and that's where we're going to focus on licensing throughout the seminar today. Now let's have a quick look what actually is a license. License is called an indirect exploitation of intellectual property. Why is it called indirect exploitation? Because there is a licensing agreement that the owner of the IP, which is called the licensor, grants the other party, which is called the licensee, the right to use the IP. But the main point is that the owner of the IP, the licensor, he maintains the ownership of the IP. If the licensor would sell it, then we would have the transfer of ownership. But in our case, in the licensing options, the licensor maintains the ownership. So basically here we have the two parties, the licensor, which is the owner of the IP, for example, your research organization. It gives the third party, the licensee, the permission to use the IP in return for payments. Now, if you think kind of strange setup, well, it's not so strange. For example, if you rent an apartment, you have a landlord and you as the tenant would be here. The landlord is the owner of the apartment. He's giving you as the tenant the permission to live in the apartment in exchange for payments, which is the monthly rent you're paying to the landlord. So basically a pretty common way of operation here. And that's what's specific about the license. Again, transfer of ownership would be different. You just sell it. But in this case, the licensor maintains the ownership of the IP. And as we've written here, the licensor, the IP owner, can be the research organization like a university. It can be a company, but it can also be an individual person. Doesn't make sense. And you've got the same options here on the licensee side. Okay, so we've been talking about IP, intellectual property. Obviously, there are different forms of IP, different IP rights. Now the question is, which IP rights can you actually license? And again, I invite you to write it in the chat box. Any idea which different types of IP rights you think can be licensed? And again, any ideas from your side are highly welcome. Just type them in the chat box. Yes, don't be shy. First answers are coming in. So we have a couple of people mentioning patents. Yes, totally true. Patents are one of the best known type of IP rights and one of very commonly used, but there are several others. And here we go. Yes, different people are mentioning the know-how, the copyright, the trademarks, patent, trademark, copyrights, and some of you very brave saying all IP rights can be licensed. Yes, thank you. Let's have a look here. So basically, we have a first group of IP rights, which is called registered IP. Here we've got our patents and utility models and registered trademarks, registered designs. The special thing about these different forms of IPs, as the title implies, registered IP, which means you have a formal way of registration. Obviously, for patents, yes, you register it with the national or international patent office. A utility model, you register. A registered trademark and registered design, as the name implies, you register. The formal act of registration. And the special thing about patent is a formal examination, but here it's basically all registration. And we have a different type of IP rights, which is called unregistered IP rights. For example, copyrights, as some of you mentioned. Also database rights, unregistered trademark, unregistered design. So basically here, you get the IP without any formal form of registration. Let's take the copyright as an example. If you write a book, you automatically have the copyright on this book. Automatically, basically in the form of creation, in the act of creation, gives you the copyright on the book. You do not have to register your book somewhere. You automatically have the copyright on the book. If you take a picture, you automatically have the copyright on this picture. So these are the main one: registered IP and unregistered IP. And some of you mentioned before know-how. Very, very good. Please do not forget there's a third group of IP, which is called soft IP, which is, for example, know-how, trade secret, confidential information. And yes, you might be surprised. You can also give a license on a specific form of know-how, on a trade secret, and we'll come to it later on. What you have to be careful on if you're giving a license for example, on a trade secret. Okay, let's move on. When would you use a licensing agreement? Well, as we're saying, you as the owner giving the right to use this specific form of the IP to a third party. We mentioned the example of the book. You wrote the book, you have the copyright on the book. Now, if you allow your publisher to make and sell copies of your book, which you own the copyright on, this means you have to give a license to your publisher to make and sell your great novel here. In the area of manufacturing, you might have a patent on your product, and you have to give, if you are sort of the inventor and you have to, or you're looking for a manufacturer to manufacture your product, you have to give the manufacturer a license on your patent. And we talked about trademark and know-how licenses as well. When do you normally do not need a license? If you're just selling your IP, what we mentioned before, the transfer of ownership. It's a one-time transaction. The buyer and the seller agree on the price, and that's it. You don't need a license. And the second option is if you're just selling your products or services. So for example, if you build a new, let's say a new toothbrush, and you have a very specific feature which is protected by a patent, and you're selling the toothbrush, you normally do, or you do not need to give a license in addition to the product. The only exception would be if you build a rather complex machine, and the machine can be used for different purposes, and you build the machine because you want to use it for a special application, and you want to make sure that no competitor of yours can use the machine for the same type of application, but you would allow anybody to use it for complete different application. So you could sell the complex machine and give a license on it, saying, yes, you're allowed to use it on these different applications, but not on this specific application where you are active in the same market. Here again, just for this differentiation, we talked about different agreement. We talked about the IP assignment, where you sell the IP. Licensing agreement is basically what we're talking about, and distribution agreement. Well, you know, if you are installing a new software on your computer, you have to agree on the end user license agreement. And here you have the distribution agreement if you need a distributor to basically sell your software. And here we have the end user licensing agreement. And from now on, we are focusing more on the patent, but please, again, do not forget about the other types of intellectual property. I noticed there are some questions now popping up in the chat, as Francesca pointed out at the very beginning. If you have a specific question because you do not understand what I'm saying, yes, please type the question here and we'll try to address it. All other questions, please keep them for our Q&A section at the very end. Okay. Now, we've been talking about external commercialization, what it is. what different forms there are, like transfer of ownership or licensing. But now let's take a minute and think about it again. We talked at the beginning about this open innovation. We said it's the open innovation funnel. You have an idea, you test it, you build a prototype, and eventually you put in a lot of time and money and effort, and you bring it on the market. And the question now is, why would you not commercialize it yourself? Why would you not bring it on the market yourself? But why should you give a license to a third party, and the third party would bring it on the market? So the question to you again, why does it make sense to engage in external commercialization? Why does it make sense to give a license to a third party, to entitle a third party to do the commercialization and not yourself? Any ideas from your side why it would be beneficial for you, for example, as the inventor, as the owner of the patent, to entitle a third party? Yes, don't be shy. Yes, first answers are coming in. Be creative. Think about different options, different motives, why it might be beneficial for you. Yes, thank you for your answers. Still some answer coming in, but let's have a look at the answers so far. So it's basically higher market penetration was the first answer. Then it was avoid investments, recover the investments, because you are a concept creator. So basically you're focusing on the first part of the innovation value chain, if you want to call it this way. Popular software products as vehicle to transport. Other companies already have customer in the market, enter different markets easily, and because no internal resources and capabilities for exploitation. Yes, thank you for these ideas. And here I've wrote a few of them. I guess you covered most of them. Basically, entry, as one of you pointed it, enter different markets. Yes, different markets you could divide. Either it's different because it's a different geography, different countries, or different application, meaning different industry. Or you could say, yes, you made this innovation, you made this new product, but actually it's not a strategic fit to your company anymore. Maybe at the beginning you thought it would be a really good fit to your technology portfolio, but either during the course of the innovation, it turned out that there is a more interesting, different application, different market, or maybe the strategy of your company sort of changed, so there is no strategic fit anymore, or it's something what we call a platform technology. Let's have a quick look at these different options, starting with the different geography and application. Let's assume you're a producer of shoes, like in this case, these nice women's shoes. And the important thing is here, you found a new way of creating a very, very shiny, colorful leather, which now you use in producing your shoes, and you're a shoe manufacturer in Germany. So basically, if you would move to different regions because you do a market study and you learn that Italy, land of fashion here, would be great for you to sell your shoes, you could think, well, you might be able to sell your shoes, you as German manufacturer, you might be able to sell it in Italy. But if you think, for example, of a more exotic country like Singapore, it would be probably very, very difficult for you and challenging for you to set up your own customer access market channel and so on in Singapore. So in this case, it would be helpful to team up with a third party to sell your shoes in Singapore. So this means here we're moving into a different region, but we're in the same industry. Now, as you mentioned, the new innovation is about creating this great shiny red leather, which you're using in your shoes. But now, for example, somebody's suggesting to you, hey, you could also use this leather to produce women handbags, purses. So here we are moving into a different industry. And let's assume your focus is really on, your expertise is on manufacturing shoes. So it would be quite a challenge for you to produce the purses. So moving into a different industry would be a good idea to team up with another partner for this commercialization in a different industry. And obviously you can have the combination of both, which would be a different industry purses in different geography, for example, Italy or Singapore. So that's the example. When does external commercialization make sense in terms of different region and different industry? And I was mentioning the platform technology. And here an example, platform technology. And if you look at the picture, I would like you to not to focus on the coin. In this case, that's not the important part of the picture, but the important part is here, this little thread here. And this thread is actually made of artificial spider silk. That's the invention here we're talking about. A very special invention created at the university. And you can use this artificial spider silk for totally different products. And I just listed a few of the products here. So the first one is implant coating. So for example, if you get a knee or hip replacement, it's very beneficial if you have a coating of this artificial implant using the spider silk, because it has improved properties for your body to sort of adapt to this new implant. Medical devices for OTC wound care. OTC means over the counter. So here it's basically for the professionals, for the surgeons, for the doctors. And here it's OTC products, which you can buy as on your own if you go into a pharmacy and buy medical devices. Functional cosmetics, so for example, anti-wrinkle creams, found out that this spider silk is very beneficial here. And now if you could say, well, it's all kind of different application in the area of medical or cosmetics, skincare. The application number 4 listed here, it's basically biosteel, which you use for bulletproof vests, like for member of the police or armed forces. Bulletproof vests normally kind of, made of steel, heavy, uncomfortable to wear. And you can make this bulletproof vest out of artificial spider silk. And as you would expect it from silk, very, very more lightweight and much more comfortable to wear. So this is a type of platform technology. The technology is about creating this artificial spider silk. And now you really need totally different expertise, different capabilities, different market access here for these totally different channels here. And so it obviously here it makes sense for you as the company focus on the generation of the spider silk and team up with different companies here who have special expertise and market channel and customer access in these totally different industries. Okay, well, some more reasons for licensing. Yes, licensing is so important, so interesting, so beneficial. There are even additional reasons why it might be beneficial for you to engage in licensing. We talked about accessing new markets, generate profit, share the risk, because obviously starting an innovation project is expensive, it's kind of risky. You can access technology, because it might be faster and cheaper to sort of buy a license instead of starting an R&D project on your own. Ensure freedom to operate. Freedom to operate means if you're starting a R&D project and you're trying to develop a new product, you have to make sure that with your new product, you're not infringing somebody else's intellectual property. And if you find out there is actually a patent, for example, from a third party, which might block your R&D project, you could engage in a licensing contract with the third party, ensuring you the freedom to operate. If this is interesting for you, the topic of freedom to operate, we actually have a dedicated seminar on the topic of freedom to operate, just by the way. If you enter into an R&D collaboration, most of the times in a collaboration, you have 2 or more partners, and each of the partner is coming into the cooperation with a special know-how, special dedicated patents, for example. So it makes sense at the beginning of the R&D project to sit together, have a cooperation agreement where each of the parties is giving the other party a license on their existing know-how, technology, IP, patents, whatsoever. Settle an infringement claim. So for example, if you're bringing your product on the market and maybe you did not do your homework and ensure that you have the freedom to operate, you might run into problems with the third party who has a, let's say, a patent on a specific aspect of your new product. And the other party might drag you to court. And in order to avoid a court decision, you can agree on a licensing agreement. And by doing so, you settle an infringement claim. And the last option is cross-licensing. Maybe you've heard the term in some areas like mobile communication, for example. Different players have so many patents that it's really difficult to move forward, come up with a new invention without infringing on a third-party patents. So in some industry, the main players get together, they give each other cross-licensing in order to really sort of have the freedom to operate for the different players again to move on with further innovation. So you see lot of really advantages for if you engage in licensing. And as you might have noticed, there is more of this part is out licensing, which means you are the licensor, you're giving a license to a third party, access new market, generate profit. And then there's also the in licensing that you, for example, get a license from a third party. And by doing so, you access the technology or you ensure the freedom to operate. Now let's have a quick look, actually motives for licensing. And I have a couple of slides here now. They're all taken from this Petless survey. And here, for example, it's the motive for out licensing patents. So meaning, why is the owner of a patent giving a license to a third party? And 4 is always very important motive, 1 is unimportant. And so here, most important one is earning revenue, ensuring FTO. Again, FTO stands for freedom to operate, stop infringement, or earn revenue on a non-core technology and enable joint R&D innovation. So that's the top 5 reasons, motives for out licensing. Now, if we look a little bit more careful and differentiating by the size of the companies, of the licensor, the black bar is large firms and red one is small firms. So you see earning revenue is much more important for the SMEs, the red bar, than for the large bars, than for the large companies represented by the black bars, whereas stop infringement or ensuring FTO is much more important for the large companies versus the red, the small and medium-sized companies. Another way to look at this is by differentiating by industry. And for example, you see in healthcare, which is the red bar, earning revenue is very important, whereas stopping infringement is way less important than for others. But for example, in consumer good, ensuring FTO and stopping infringement is much more important than the others. So kind of interesting to look at the data to see the differences between the different players in this field. Well, if you have motives for out licensing, there are also barriers to out licensing. And the number 1 barriers for out licensing is the potential loss of competitive or technological edge, really by far the most important one. Now, if we drill down a little bit further here and make the differentiation, and this time not by industry or size, but the white bar is firms who are not out licensing and have no intention to do so. The black bar is not out licensing yet, but planning to do so. And the red one is actually out licensing companies. So you see that the number one motive, the fear of potential loss, is by far the most important one for the companies who are not out licensing and have no intention to do so. Yes, it really stays most important motive, or in this case, barriers, but still not the most prominent one, or at least not such a big difference. And also interesting to note, a barrier that the technology is not developed enough is really not so important, seen by companies not out licensing. And once the company are engaging really in these discussions, they understand, oh, maybe there is a potential problem here. And so on, difficulties identifying the right partners and so on. I don't want to spend too much time on these. You'll all got the charts, so you have the option to study them in more detail if they are more interesting for you. Channels to find potential licensees, well, informal networks, own research, being contacted, events, networks, and research specifically in patent databases. Now, this was out licensing. Now moving on to in-licensing, motives for in-licensing. And here we have number one motive, ensuring the freedom to operate, then closing technological gaps, enabling rapid time to market, and expanding your business in different direction. And again, moving from the motives to the barriers for in-licensing, the price is too high, well, no need. Refusal of the licensor to grant a license, absence of sufficiently well-working market, the risk here, and the difficulty identifying a potential partner here. Okay, as I said, if you would like to study the data in more detail, you have a chance later on to do it. I would like to move on now regarding, if we move on to the next stage, negotiation. Let's assume you learned about a new technology and you did a very first, got some information. It might be interesting technology for you to license in. Question to you, what would you do before you actually sit down with the licensor to negotiate? So basically, what kind of homework would you do? What kind of information would you try to get before you actually sit down with the licensor to negotiate? And again, I invite you to type it into the chat box if you have any ideas of what you would do before you actually sit down with the licensor. What kind of research would you do? Any ideas? Don't be shy. Okay, the first answer coming in, check out if there is an open source alternative. Next option is hypothesis on your future earnings. Protect IPR. So the answer of hypothesis on your future earnings, it's already very far into the future, kind of sophisticated homework. I'm actually more talking about sort of first steps. For example, what I mentioned here, somebody saying is licensing necessary. I would say before the negotiation, you try to get information on the other party. If you're the potential licensee, you would like to gather some information on the potential licensor. What do I mean by this? So for example, is this the IP you are interested? Is it the only IP the licensor has? for example, the only patent, or does your potential licensor has several patents in this field? If there are several patents, so for example, it's a university research organization you would like to get a license from, and they have several patents in this field, you can be pretty sure that they have a lot of knowledge in this field. The other way around doesn't mean that if they have only one patent, the patent is not of potential value for you. But I would like to see the other way around. If there are several patents, the chance is much higher that they really have been working on this topic for quite a while and they really know what they're doing. Information regarding the technology and its context. Yes, let's assume you as the potential licensee, you already have an existing production equipment. You have a set of machines, technical equipment, and you would like to understand if you use this new technology, can you use your existing machinery working with this technology, or is there a risk that you have to buy new machines, for example? Very important information regarding the legal status of the right, which means, yes, the potential licensor, he has this patent, but is this patent actually still alive? I hope, or I assume you know, that the patent has to be alive, which means the owner of the patent has to pay a renewal fee year by year. And if the patent owner stops paying the renewal fee, the patent lapses, which means the patent is not valid anymore, which means the owner of the patent, they can show you the patent certificate hanging on the wall from, let's say, 10 years ago, proud owner of the patent, but if they have stopped paying the renewal fee, the patent is not valid anymore and you are free to use it. The same applies. A patent is a territorial right, which means, at least so far, there's a big change coming up, but so far, if, for example, in the case of our shoemaker, there is a patent, or they have the patent for this nice coloring the leather in Germany, and you are the shoemaker in Italy and say, hey, that's kind of interesting technology. And if there is no, or the patent is not valid in Italy, it's nice that there is a German patent on this, but if there is no Italian patent on it, you're free to use this technology in Italy. Assuming you're producing in Italy and selling it in Italy, you're fine. You're not allowed to produce it in Italy and then selling it to Germany, obviously, because there's this German patent. But that's the system of the patents. And so you should do your homework and understand the legal situation of this patent. Well, information regarding the business environment, obviously, you should understand, is it an interesting business to be in? And I would strongly recommend you to have an NDA, a non-disclosure agreement, once you sit down and with the potential partner and start into the more detailed discussion. We've been talking about the different forms of contracts or legal documents which you should use or which is recommended in our last session on tech transfer. And NDA is one of them at the very beginning, which gives you more freedom to talk about confidential information. Well, here are examples for due diligence. Once you go further into this topic, let's take our example from before, the dyeing of the leather, the very nice, colorful red leather. And the interesting part is here that normally dyeing of the leather, you use organic solvents, and organic solvents are kind of nasty, they're expensive, they're difficult to rid on, they're harmful for the environment. And so this new process is you're using a water-soluble dye stuff, which has many, many advantages. And it's protected by a patent and it's supported by secret know-how. And so basically, moving on a little bit, looking at the timing, what kind of due diligence would you do? Yes, you would check that the patent, first ownership, that the person you're talking to as your potential partner is really the owner of the patent. Regarding the legal status, as mentioned before, that the patent is really alive and that the patent is really active in the countries you are interested in, meaning you have the right geographical scope. And that the patent is really about the interesting technology and the potential application which you are interested in. Where can you find out where the patent exists or who is the owner of the patents? It's the EARSC. It's the database of the European Patent Office. It's a huge coverage, more than 130 million documents. You can find it here. I like it. It's free to use. It's kind of easy to use. However, there are other patent databases out there, some free, like from every national patent office has some international patents. There's Google Patents, and there are also commercial databases which are you have to pay for using them. But yeah, I just recommend EARSC, free to use and really big coverage, and also very helpful for identifying potential partners. Well, looking at the time, actually don't have time to go into the details how to use them. But as I mentioned, I kind of like it, interesting, and much more easy to use than before using the advanced version. I mentioned trade secrets before. If you're interested in getting a license on a trade secret, you should do your due diligence on the trade secrets in respect to your licensor, your potential licensor. What kind of trade secret policy do they have in place? Which means a trade secret is only valuable information if it's a trade secret, meaning there should be in the policy stated that only very, very few employees know about this trade secret, that the licensor has specific measures to keep the trade secret as a trade secret, because once the information is out there, there's no protection anymore, because a trade secret is not covered by a patent. So a trade secret is only valuable if it's a secret. As soon as it's out there, there is no way to sort of get the information back. The value is lost. So you're interested in understanding the trade secret policy. These very few employees, do they have a confidentiality agreement, and are there already other licensees in possession of the secret? Well, if you move on to the licensing agreement, because your discussion was very helpful and very good, and you see big benefits in going to an agreement with this potential licensor. If it comes to the licensing agreement, there is really no standard. That's why it makes it more challenging, but also more interesting and more difficult, because you can really adapt it to your specific needs and situation. I can only talk about the main topics, and that's basically the list of the main topics which you should define in your licensing agreement. And I mentioned this is sort of the basic seminar, and we have the advanced seminar where we really go through these individual topics and discuss what you should define if we're talking about the parties, why it's helpful to define the purpose, and what should be in the definition, and so on. So if you're interested in this and this is relevant for you, please look at our training schedule at the European IP Helpdesk. You can find it here in the training section. And we have the training on the freedom to operate coming up in the next couple of weeks, as mentioned before, and also this training on the licensing advanced. Okay, coming toward the end, I mentioned before, I wanted to introduce you to a case study. The case study is on a company, Orkan Energy, a spin-out of the Technical University of Munich, and I actually wrote 2 case studies on this company. The first one published by the European Patent Office, and if you just Google EPO, European Patent Office, and SME case studies, you find a list of 12 different case studies. One of them is on the company Orkan Energy. That's the title of the document here. They're focusing on waste heat. We don't have to go into the detail. Basically, what they did, they had a single installation to recover the waste heat, for example, in this case of a biogas installation. And they were able to move from the single small installation in Germany, Italy, to the large installation in Asia by doing a licensing deal with a Chinese partner, and they created much bigger installations. And this is an aerial view of a huge electricity plant in Myanmar, generating electricity from natural gas. And you see the gas turbine here, and next to each of the gas turbine, there is this big product of the company Orkan. So that's why it was a great deal for them, and they were only able to do this because of this licensing deal with the Chinese partner. And this is the second case study on Orkan Energy with the title Licensing Out to China. And this case study you can find on the website of the European IP Helpdesk using this link here. Okay, so coming to an end, then if you really go to the negotiation, please keep in mind that the licensing agreement is a strategic choice and it's a long-standing relationship. That's why it's saying it's very important for you to really think about careful before you start a licensing agreement with a potential partner. It's interesting and it's challenging because you have these different aspects, legal, technical, financial, and it's this ongoing relationship. I mentioned before, transfer of ownership. If you sell your patent, that's a one-time transaction. You agree on the price, that's it. On licensing agreement, you really, you're having an ongoing partnership. That's why it's important to really search for a win-win agreement. Be prepared to negotiate. That's why I said here, do your homework, do your due diligence. And it's important to discuss the agreement as a whole. Please don't get into a gridlock over details. Really try to reach an agreement which is beneficial for both partners. Well, it's 3 o'clock now. Pretty good on timing. If you have any questions, please visit our website. And here it's the email of the help desk. If you have specific questions, I mentioned this is the helpline where you can turn to for your specific advice. And with this, thank you very much for being with me for the last hour. Thank you very much for your active participation. Makes it much more interesting for me, hopefully for you as well. And as mentioned before, we have time now for Q&A. If you have some time to spare, if you have to run back to your desk, to your duties, thanks for listening. You'll find a feedback form. Please be so kind to fill in the feedback. If you have some time for Q&As, you can write your questions now in the chat box. If you posted them before, please be so kind and post them again, and we'll try to answer them. Mm-hmm. Thank you, and let's see if you have any questions here.
Thank you, Christian. Thank you very much. Indeed, any questions, please go ahead in the chat. I can already see exactly one from Benoit. So is in-house developed programming code unregistered IP like a book? Is it the correct questions, Benoit? And eventually you, Christian, you can answer to this one. I don't know if you can see it directly as well in your chat.
So yes, I guess it was about the software, if I can remember the question correctly. Yes, software, there are different forms of protection, different form how you can protect your software. So for example, you have database, there's a database, right? You have the code. Yes, it's protected by the copyright. This is the very important form of protection for software. But again, you can do it some clever way by combination different forms. And there's also a dedicated seminar on the topic of software and IP, which I can recommend you for this if you would like to understand more of this. But yes, copyright is the most important form here for software. So, sorry, most important form of protection, mode of protection for software, yes.
Thank you, Christian. Okay, Benoit replied, perfect. I don't see any questions written currently. otherwise, indeed, I guess we can reach you either to us or to you directly, in case they have any other questions. Dietrich, okay. Do you read it, Christian?
Here we go.
Yeah.
Can a single formula like to transform a remote sensing-based vegetation index in yield prediction be matter for such a licensing agreement? Okay. Can a single formula like to transform a remote sensing-based vegetation index in yield prediction? So I must say I'm not an expert on this one. What I can say, for software, you cannot get a patent. For licensing agreement, yes, you can. Normally the question is always, can you get a patent on software? And for in this case, you cannot get a patent for software per se, at least in Europe. However, if you have a technical effect produced by the software, produced by any kind of algorithm, and so you can get a patent on this. So the technicality, as it's called, that's the important part. If you have a technical effect by your software, which means by your algorithm, use an algorithm to analyze some data, and then you come to a decision, and then, I don't know, a gate opens or closes, or you have a different, a red light, a green light, whatever it is. This would be the technical effect, and then you have the option of getting a patent on this one. Hope this answers your question. And again, if you have more specific questions, I would recommend you to listen to our seminars on these software and IP, as it's called, I guess. Another question, how to license technology or prototype if it's not a commercial product? Well, I hope I understand the question correctly, but it does not make a difference. Assuming you have, for example, a patent on the technology, it does not make a difference whether the technology is at a very early stage, basically just the idea, or sort of in the middle that you have a prototype, but not yet totally tested under rough market conditions, or whether you are all the way down sort of at the value chain that the product is already on the market and has been on the market for a while. It does not make a difference. You can, if you have a patent, you can, for example, give a license on this patent. I hope I understood the question correctly. If not, please ask again.
All right. So
Okay.
I don't see Paulo Fracas. Yes.
Okay. Yeah, they come.
Perfect. I don't see other questions. Daria, thank you. It was relevant. Great feedback. Christian, in case we don't have questions now, we can thank you again. And then again, can you share with us perhaps this new seminar that you were mentioning before about licensing and software? So it might be interesting to share with them.
Yes, and again, please go on the website of the European IP Helpdesk and the section training. There are really so many trainings now for beginners. Basically, what is IP, what it's about, and to the more specific details. For example, IP and software or artificial intelligence and IP. Really very, very interesting topics, and we have a great expert on this one, Eugene Sweeney. He's an expert on this topic of software, for example. So you can also address your more specific question to him then in the area of software, for example. But again, so many different training sessions now, seminars, for example, on the freedom to operate, which I mentioned before, or on different aspects like IP in Horizon Europe. So this might be interesting for you if you're thinking about being active in a Horizon Europe project, for example.
Perfect. Well, Christian, thank you very much for these insights. I think it was very relevant for our project, indeed, Horizon and the eShape. As you know, many of our people, of our attendees as well, are eShape pilots that have been developing during these 4 years, operational products in the Earth observation field, coming from prototypes, concept ideas. So hence also, I guess, this kind of questions about licensing are connected to a not commercial product yet. So I think that we spike again some more interesting questions for this. And indeed, again, thank you very much. And we will provide in any case the link with the recording. And I hope to see you soon in any case in any other webinars.
Yes, thank you for the chance. One more thought which I had. It's called Horizon IP Scan. It's another free service. If you are engaged in one of these European corporations and you basically would like to check with an expert, how does it make sense setting up the corporation that I really don't give away all my IP, that I really benefit of this kind of IP sharing in such a corporation? It's called Horizon IP Scan.
Okay.
Again, actually on our European IP Helpdesk, we have some info sessions on this Horizon IP Scan project. And if this is relevant for you, just listen to one of these sessions and you can learn more about this. Again, as I mentioned, the free service for you. Other than that, thanks. It was very interesting, very nice to be here. Thank you for the great feedback. Again, hope to see you again soon, and good luck and goodbye. Thank you.
Thank you very much. Goodbye.
Thank you.
Goodbye,
Thank you.
everybody. Bye-bye.
Bye.